A big question is now before the courts. Well, can the police handcuff you? This issue has sparked a major legal debate. The Andhra Pradesh High Court has stepped into the picture. It has asked the central government for its response. The case focuses on a new law. Section 43(3). Bharatiya Nagarik Suraksha Sanhita, BNSS. The rule lets police use handcuffs during arrests of people accused of serious crimes. This matters to everyone. It touches basic rights of citizens. It also concerns police powers across the country. The outcome will define the line between public safety and personal liberty. The legal action was started by lawyer Kayur Akiraju. He filed a plea in the Andhra Pradesh High Court. He argues the rule is unconstitutional. He says it violates two fundamental rights. Article 14, Article 21. Article 14 promises equality before the law. Article 21 protects life and personal liberty. The main legal worry is about the broad power given to police. The petition argues that Section 43(3) gives police officers too much discretion. It allows them to decide when to use handcuffs without needing to get permission or even record detailed reasons for a judge. Critics fear this could lead to the power being used as a routine measure rather than an exception. This raises concerns about the potential for misuse. A person accused of a crime could be handcuffed and paraded in public. This carries a heavy social stigma. It can damage a person's reputation before any guilt has been established. The plea states that such wide and unchecked power fails the test of proportionality. The new law lists several serious offences where handcuffs can be used: murder, rape, acid attacks, terrorism, drug-related crimes, illegal possession of weapons, human trafficking, offences against children, offences against the state. The debate over handcuffs is not new. The Supreme Court of India has made important rulings on this issue. These older judgments feed into the current legal challenge. Sunil Batra versus Delhi Administration, 1978. The court condemned routine use of handcuffs and leg irons on prisoners. It called the practice degrading and an affront to human dignity. Putting a person in irons should not be a normal procedure. It is an extreme measure that needs strong justification because it goes against a person's inherent worth. Prem Shankar, Shukla versus Delhi Administration, 1980. The Supreme Court went further. It called routine public handcuffing inherently inhuman and unreasonable. Handcuffs only in very rare, exceptional circumstances. The court added a safeguard. Police must record reasons in writing when they think handcuffs are necessary, and present those reasons to the presiding judge, who will approve or disapprove the restraints. Section 433 appears to shift away from those precedents by explicitly granting statutory handcuffing power. So what happens next? The ball is now in the central government's court. Union Ministry of Law and Justice, Union Ministry of Home Affairs must prepare a formal reply to the notice from the Andhra Pradesh High Court. They must defend Section 43(3). They will likely argue this power is necessary for law enforcement, prevent dangerous accused persons from escaping custody, and ensure the safety of police officers and the public. The government must present compelling reasons, show that the provision does not violate fundamental rights, and argue it is a reasonable restriction on personal liberty. Once the government files its reply, the High Court will schedule further hearings. Both sides will present detailed arguments. The petitioner will re-emphasize the presumption of innocence, stress human dignity, and cite past Supreme Court rulings. The government will argue necessity in the context of modern-day crime. The court must perform a delicate balancing act. The final word will come from the judiciary, which must lay down clear rules for handcuffs.